Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala sayyidina Muhammadin asyrafil anbiya wal mursalin wa ala alihi washabihi ajmain. Assalamualaikum warahmatullahi taala wabarakatuh. Salam sejahtera and welcome to our another live session. Okay, all right. I hope that you are inspired or you are inspired by that UITM di hatiku, the team song of UITM. Right. Assalamualaikum and welcome salam to those who are greeting me. Okay. Okay. I suppose most of you are from group. I think here, if I'm not mistaken, let me just check. Sometimes I lost track of the group of students. You are from BA 13, 14, and 15, isn't it not right? Okay, all right. So if that is so, uh, just a point that thank you very much for all the greets. Okay, right. Well, take a couple of seconds if you have not subscribed to this channel. Take a couple of seconds to subscribe to it. I really appreciate your support. And as usual, please mark your attendance here via future. And here you have to be truthful with yourself. If you are not in this session, please do not mark your attendance as present. If you are having any difficulties in attending this session, such as you are not well, and if you have got an MC or time slip from the Pusat Kesihatan, please also submit those excuses on YouTube, right? Okay. Right. Insofar as the lecture is concerned, today we are going to talk about one of the important elements to make an agreement a contract, okay, which is the element of free consent, right? Uh, well, the other elements that I've shared with you in the other live, okay, if you have not attended a lecture on that, you can actually view the live lecture that I recorded as well as shared on my YouTube channel. All right, please do so. Consider those areas that I have not given you live session had been fully covered. Namely, I suppose consideration, intention to create a legal relationship, and capacity that had been fully covered. Okay, in my previous live session. All right, today we're going to talk about free consent. Right, as a precondition, just like any other of my life, okay, I need you to have in front of you one, okay, the Contract Act 1950, okay, two, the materials that I shared with you on WhatsApp, okay, which is actually the reproduction of my slides, and three, whatever references that you have with you regarding the topic of law, Malaysian law of contract. I hope that you have it with you, all right, in front of you, because every time I make a reference to some of the provision, I would actually prefer for you to read it together on your own at the end there. Right? Okay. Are you comfortable? Are you ready to learn this element of free consent? Okay, if you are, okay, so am I. I'm quite excited also. All right, free consent. Okay, let us look back at Section 10, subsection 1 of the Contract Act. Okay, we have seen and read this provision previously when we were discussing about the elements of capacity. All right, this section is very important because in this section, okay, it embodied a number of elements to law contract. I heard somebody is drilling. Sorry about that sound. I have already made sure that okay, the place, the voice level is conducive. Anyway, we do not know. Okay, other people might have been doing renovation or drilling. So if you are interrupted by a drilling sound, I hope that you can give more focus to my session. All right. So section 10, you have it with you. Are you reading it now? Okay, give me a sign. Okay, that I know that you are following my lecture. All right. If you look at section 10, subsection 1, all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. So if you look at this section, as I say, there are a number of elements. Okay, um, one is competency. Okay, two is the consideration must be lawful. Three, okay, the object must be lawful, and four, it is not expressly declared to be void. But we just want to focus on if they are made by free consent. All right. So if two parties entered into an agreement, the consent that they had given to enter into that agreement, okay, must be free from any element that may vitiate, okay, that consent. Okay. When is it said that a consent is said to have been given freely? Okay, if you are not a Malaysian, or if you are viewing this from you are a foreigner who do not understand Bahasa Malaysia, I will actually deliver my lecture mixed using English as well as Bahasa, right? Or Bahasa Malaysia. Right. To determine whether or not consent is given freely, you have to look at section 14 of the Contract Act. Are you there? Are you now looking at section 14? Give me some sign to show that you are now looking at section 14 of the Contract Act. All right. Wow. We have about 46 students. Only one responded to that. I do not know what the rest are doing. They might be multitasking, doing something else, which is not actually something preferred by me, or something which is good on an online class or a live section like this. All right. So if you have your section 14 in front of you and you can read it together with me, all right. According to section 14, consent is said not given freely when it was caused, okay, by 5 elements or by 5 matters, right? Consent is said not to have been given freely if the consent to enter into the agreement is caused by 1, coercion, as the one provided by section 15, or in Bahasa Malaysia, paksaan. Okay, pronounce it correctly, coercion, okay, or paksaan. Okay. Secondly, by undue influence, as defined by section 16, or in Bahasa Malaysia, pengaruh tidak wajar. Third, by way of fraud, even though that it is spelled F-R-A-U-D, but to pronounce it, you say fraud, as defined by section 17 of the Contract Act. In Bahasa Malaysia, okay, you can use the term penipuan, or it is quite acceptable. Okay, the word fraud, F-R-O-D, is quite acceptable. Okay, to describe fraud. Okay, in Malaysian language, right? And fourth, misrepresentation, as defined by section 18, right? Misrepresentation in Malay is salah nyataan, and lastly, by way of mistake, as those provided by section 21, 22, and 23. So these are the vitiating elements, okay, to free consent. So if consent to an agreement is given by any of these circumstances, okay, then the agreement or the consent to that agreement, okay, is not given freely. Sekiranya, okay, persetujuan untuk membuat apa-apa perjanjian adalah disebabkan oleh perkara tersebut, iaitu paksaan, pengaruh tidak wajar, fraud, salah nyataan, dan kesilapan, maka persetujuan yang diberikan untuk membuat kontrak itu dikatakan telah tidak diberikan secara sukarela. If you have to translate in bahasa, right? Do you understand that? Okay. We don't worry about that. We shall, in this live session, we shall go into the detail of it one by one. We will explore what is coercion. We will explore what is undue influence, fraud, misrepresentation, or mistake. Okay. Right? How so far? Okay, how is it so far? Do you follow me? Okay, you can always use the live chat or the icon. Okay, give me a lot of hearts, give me a lot of thumbs up. Okay, right, it's just to appreciate that you are at the end there. Currently, there are about 52 students. Okay, in this live session. Oh, I might have forgotten. Have you all sit for your uh, first coursework online quiz last? I mean, last week, because it was scheduled on the 5th week, isn't it? Did your tutor? You are not with me, isn't it? For your tutor or your tutorial, you are not with me, isn't it? Okay. So have you done? So have you done your online quiz? Okay, you can type there on the chat, live chat, saying that yes, I have not, or give a thumb up or thumb down. Okay, 100%. Okay, thank you very much. Okay, all right. Okay, now let us now continue to look at, okay, what happened if consent is said not to have been given freely. Apa yang berlaku sekiranya persetujuan untuk membuat kontrak ataupun untuk membuat perjanjian itu tidak diberikan secara sukarela. Okay, I will make a general statement because sometimes the effect of consent not given freely will lead into a contract to be void, and sometimes, and in other situations, it will lead the contract to be voidable. So if a consent was not given freely, then the contract could either be void or voidable. Jika persetujuan untuk membuat kontrak tidak diberikan secara sukarela, kontrak itu boleh dikatakan kontrak boleh batal ataupun kontrak terbatal. So void contract is contract terbatal. Voidable contract is a contract boleh batal. Void or voidable, right? So let us look at the meaning of what is a void contract. Okay, the definition of void contract is in section 2, paragraph G. If you have section 2, paragraph G, okay, I'm sure that you can read together with me. Okay, according to this section, okay, a void contract is an unenforceable contract. Okay, so this contract cannot be enforced at all by law. Okay, so because it is a void contract, okay, the contract did not give rise to any right or obligation. None of the contracting party has any right under the contract, nor they have any obligation under the contract. So the contract is said to have been void from the beginning. From the beginning, when the party make that agreement, it is void. Okay, or we use the Latin term void ab initio. Okay, void ab initio. If you do not know the spelling, okay, I can share you the spelling. Okay, void ab initio simply means it is void from the beginning. Since it is void from the beginning, okay, it did not give rise to any right or obligation on any of the contracting parties. Okay, so that is the meaning of a void contract. It is not non-enforceable or not enforceable at all, right? So if you understand what is a void contract, I will continue to tell you or to explain to you what is a voidable contract. Okay, do you want to know what is a voidable contract? Or some of you probably want to share with us, the definition of voidable contract. You can use the live chat, right? So the meaning of voidable contract is provided by Section 2, Paragraph I. Okay, again, you have the Contract Act with you. Okay, you can turn to Section 2, Paragraph I, right? So the section says that a contract which is voidable is a contract that is valid in the beginning. It is valid in the beginning until it is terminated, or the other term for termination of a contract is repudiated. Until it is repudiated by the person or by the parties whose consent that was not given freely. So from the beginning, let's say A and B enter into a contract, the contract is valid. Okay? But if it is discovered that one of the contracting parties' consent was not given freely, he has the option, either to terminate the contract and claim for damages, or the other choice that he can use is to proceed with the contract. So voidable contract can leave so much of option, to the person whose consent that was not given freely. He can either opt to terminate the contract and claim for damages, or he can continue with the contract and then claim for damages. So since it is a contract which is valid from the beginning, there are certain rights and obligation arises at the beginning of the contract. Okay? Because it was valid. Okay? But those rights and obligation, will uh, no longer exist if it is terminated. Right? So a contract is voidable if one of the contracting parties consent to the contract is vitiated by some of the element that I mentioned just now. Okay, jadi kita dah tahu at this point of time, what is a void contract, what is a voidable contract. Okay, so what type of elements that vitiated free consent will lead to a void contract, and what types of elements that vitiated free consent will lead to a voidable contract. Apakah perkara yang boleh menyebabkan satu kontrak itu jadi kontrak terbatal, void ab initio, or a voidable contract. Okay, for this you have to look at section 19. Okay, section 19 and section 20. Okay, section 19 and section 20. If you look at section 19 of the Contract Act, it says that when consent to an agreement is caused by coercion, is caused by fraud, or is caused by misrepresentation, the agreement is a contract voidable at the option of the parties whose consent was so caused. So there in section 19, there are three situations where if consent to an agreement is made by any of those three situations, coercion, fraud, and misrepresentation, the contract is a voidable contract. Okay, at the option of the person whose consent that was not given freely. Okay, and if you look at section 20 provided that Okay. When consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the parties whose consent was so caused. Right? So, reading these two sections together, we know and understand that if consent to a contract or to an agreement is either one, made by coercion, two, made by undue influence, three, by way of fraud, and four, by way of misrepresentation, the contract is a voidable contract. Okay? The contract is a voidable contract jika persetujuan untuk berkontrak itu disebabkan oleh empat perkara tersebut. Paksaan, okay? Yang kedua, pengaruh tidak wajar. Okay? Yang ketiga, salah nyataan. Dan yang keempat, okay, fraud. Okay? So, coercion, undue influence, fraud, and misrepresentation. Okay? You probably say that, oh, sir, what about if it was made by mistake? Okay, right. Insofar as mistake is concerned, okay, you can look at section 21, okay, of the Contract Act. Okay, if consent to an agreement, okay, was given under a mutual mistake, where both of the parties to the agreement were under a mistake as to a matter of fact, which is essential to the agreement is void. Okay, this is provided by section 21. Okay, so a void contract, if consent is not given freely, is when the consent was given by mistake, mutual mistake of both parties to the fundamental of the agreement. Right? So there you are. Ada kontrak, kalau persetujuan tidak diberikan secara sukarela, dia jadi kontrak terbatal macam mistake. Dan ada kontrak yang sekiranya persetujuannya diberikan bukan secara sukarela tetapi melalui paksaan, melalui undue influence atau pengaruh tidak wajar, ketiga melalui fraud, dan keempat melalui salah nyataan, kontrak itu menjadi kontrak boleh batal. Siapa yang boleh membatalkannya? Okay, itu adalah pilihan ataupun option yang ada pada orang yang dia punya persetujuan untuk berkontrak disebabkan oleh empat perkara tersebut. Alright? Are you still with me? Okay. I hope that you are. We so far have about 59 students inside the class, inside the session or listening to the session. Okay, thank you very much for your responses. Now, I promise you just now, we are going to go into detail all of these elements that may vitiate free consent. Semua elemen-elemen yang boleh menyebabkan satu persetujuan untuk berkontrak dikatakan tidak diberikan secara sukarela. Okay, the first one is coercion. Okay, law of contract is very easy because why? We have the section to explain to us what is it. So, coercion is provided by section 15. Okay, so according to section 15, if you have the section 15 with you, I really appreciate you, then you can read it together with me. So, what is coercion? Coercion is the committing or threatening to commit any act forbidden by the penal code, or the unlawful detaining or threatening to detain any property to the prejudice of the person, of any person whatsoever, with the option of causing any person to enter into an agreement. Right? So that is the meaning of coercion. Okay? So it's actually either committing or threatening to commit. You melakukan ataupun you ugut untuk melakukan. Okay, any act which is forbidden by the penal code. Let me just explain to you what is penal code. Okay, the penal code is the law, the written law in Malaysia that created an offense. In Bahasa Malaysia, it is called Kanun Keseksaan. If you make a search, okay, with the word Penal Code Malaysia or Kanun Keseksaan Malaysia, okay, you will notice that, okay, the search engine will give you some of the choices of downloading some of the soft copy penal code. All right. So penal code is the law in Malaysia that provided an offense for criminal act. So there are too many, okay, things which is criminalized under the penal code. Okay, among the most popular one which you can remember is probably murder, section 302 of the penal code, or cheating, or robbery, or housebreaking, or rape. Okay, these are among, okay, the offenses created by the penal code. Right? So basically, what Section 15 of the Contract Act, okay, provided was that if with the intention of causing someone to enter into a contract, you had committed any offense under the penal code, or at least you threaten to commit an act which is forbidden by the penal code. Let's take an example that, okay, you want a person to enter into an agreement, okay, then you threaten, okay, to kill, okay, the wife of that person. So that is threatening to commit an act forbidden by the penal code, because murder is forbidden by the penal code. Murder is an offense under the penal code. So if your intention is with the view of causing someone to enter into an agreement, either with you or with anyone else, okay, you threaten to commit or you committed, okay, murder, okay, even if you agree to enter into the contract with that person or with that someone else on the basis of that, okay, threat or commission of an act forbidden by the penal code, okay, you can always, okay, repudiate it later. Okay, you have a choice. Like if you want to continue, you can continue. But if you choose not to continue, you can just, okay, challenge it in court, saying that, well, I entered into this agreement because I was coerced. Okay, when, okay, someone threatened me to threaten, or someone had committed, okay, an offense under the penal code, right? So that is one. Secondly, with the intention of causing another person to make an agreement, you had unlawfully detained or threatening to detain the property of another. Okay, like, so let's say if I want you to enter into an agreement, okay, I hold your handphone. I said that I'm going to hold on to your handphone until you sign an agreement, either with me or with anyone else. Okay, so even if you sign an agreement with that person, okay, that agreement is a voidable contract. Okay, there are a number of cases on this. Among the case that the landmark case like that you can use to describe coercion can vitiate free consent is the case of Kesarmal. Okay, Kesarmal, son of Lakshman Das and Valia Pachetia. Okay, what happened in this case? The party in this case had signed a transfer of a piece of land, okay, under the order of the ruler, okay, and when he signed this agreement, it was in the presence of two Japanese officers, right? So in the presence of two Japanese officers, he signed an agreement. Okay, certainly, okay, there was some element of threat. If he did not sign, probably the two Japanese army officer will execute him. Okay, because if he does not want to sign it. So the court in this case held that even though that, okay, the party to the agreement signed the agreement, okay, the consent was not given freely and the transfer become voidable at the will of the party whose consent was caused by coercion. So that is one. So basically, if you commit or you threaten to commit an act which is an offense under the penal code, or you detain or threaten to detain the property of another with the intention of causing that person to enter into an agreement either with you or with someone else, okay, that agreement, if you consented to it, is because of coercion. And due to that, your consent is not given freely, and you have the option either to continue with the contract or, okay, you can terminate the contract. Okay, in both cases, you can claim for damages. All right. Okay, do you understand that? Okay, you want further elaboration? Go ahead. Okay, you can ask me in the live chat. Okay, if you are okay with it, I will continue to look at the other element. Right? Should I look at the other element? Shall I continue to discuss the other element in my lecture? Okay. Just heart, no messages. Tak ada ya. Tak ada messages. Okay, just hati-hati saja yang kau bagi pada aku. Alright, okay. Then let us look at the second situation. The second situation that may vitiate free consent is undue influence. Okay, pengaruh tidak wajar. Right? In short, if the contract that you entered, okay, with anyone, because you had been unduly influenced, okay, you have the option either to continue with the contract or to claim for damages, or you can repudiate the contract because your consent is not given freely and the contract that you entered was a voidable contract. All right. So what is undue influence? Undue influence is defined by section 16. Okay. There are a number of subsections there. Let us focus on subsection 1. Right? If you have the contract act with you, please refer to section 16 and let us read them together. So according to section 16, subsection 1, a contract is said to be influenced by undue influence where the relationship subsisting between the parties are such that one of the parties is in the position to dominate the will of another and uses that position to obtain an unfair advantage over the other. All right? Don't worry about, okay, this legal term which is long, but as I said, when you read any provision, if you read with proper intonation, pause at the proper place, you can better understand it. All right? So basically, it says a contract is said to be induced by undue influence. Okay, where the relationship subsisting between the parties are such that one of the parties is in the position of dominating the will of another and uses that position to obtain an unfair advantage over the other. Alright, if I were to translate it, satu kontrak itu dikatakan telah disebabkan oleh pengaruh tidak wajar di mana perhubungan antara pihak-pihak adalah salah seorang daripada pihak-pihak itu berada di dalam kedudukan untuk mendominasi kehendak pihak yang satu lagi. Dan dia menggunakan kedudukan itu untuk mendapatkan faedah yang tidak adil daripada orang tersebut. So that is if you were to translate it. So there are a couple of elements that you have to see in that section. to see whether or not, okay, a contract had been induced by undue influence. First, the relationship between the parties. There must be a relationship. Mesti ada hubungan antara kedua-dua belah pihak. Second, where one of them, okay, can dominate the will of another. Satu pihak boleh mendominasi kehendak pihak satu lagi. Dan yang ketiga, he used that position to obtain an unfair advantage. Dia menggunakan kedudukan itu untuk mendapatkan satu faedah yang tidak adil. So these are the three things that you should look into. First, there must be this relationship. Two, where one dominates the will of another. Three, he uses that position to get an unfair advantage. Yeah, if you have to think about when does a person or when is a person to have the relationship where he can dominate the will of another, well, very difficult, isn't it? However, it is made easy by the circumstances in subsection 2 of section 16. So in section 16 subsection 2, the law implies when a person is said to be in the position to dominate the will of another so that he can use that position to get an unfair advantage. So there are a number of paragraphs there. Okay, the first one is paragraph A, where he holds a real or apparent authority over the other. Itu ada dalam section 16 subsection 2 perenggan A. Okay, di mana dia mempunyai kuasa sebenar terhadap seorang yang lain. Okay, if you are reading together with me, okay, you are following me, then you can easily understand what I'm talking about. So he is in the position of a real or apparent authority over the other. Okay, if you are to imagine when is a person having a real and apparent authority over another person? Well, I can see that a father and his children. The father has a real authority over the children, isn't it? Okay. Normally, when a father gives instruction, the children will do in whatever culture or whatever religion, okay, that you professes, okay, or that you profess. It is very clear that, okay, father and son including daughter lah, yeah. Okay, father has apparent authority, okay, toward the son or mother for that matter lah, okay, because of the level among them in the society. All right, so that's one. Secondly, probably husband and wife. Husband has a real and apparent authority, kuasa sebenar dan jelas terhadap isterinya. Or an employer and employee. Okay, an employer who employs an employee has, okay, a real and apparent authority over, okay, the employee. Or even a lecturer and the student. I'm being your lecturer, I have a real and apparent authority over you. Okay, if I am to chase you out from this session, you have to leave because that's the apparent authority that I have. Because if not, I can punish you. All right. So these are the type of relationship that we have to look into. So when a person holds a real or apparent authority over another person, and he used that position to get an unfair advantage over the other person, then it is said that, okay, if that person entered into an agreement with anyone because of the real and apparent authority, okay, of the other person, okay, he is said to be in the position of dominating the will of another. Okay, I can give you an illustration. Okay. Let us look at illustration A, okay, where it is said that in illustration A, okay, if you are still with me, okay, illustration A, you can read it on your own, we can read it together, but illustration A says that A having advanced money to his son, A give money to his son during his minority, while, okay, the son is still a minor. It supports him. Upon B's coming of age, when B had come to the age of majority, telah dewasa, okay, by misuse of parental influence, the father tell the son, okay, a bond from B for a greater amount than the sum due in respect of A advance. All right, A asks B to sign. Okay, now that you are big enough, okay, you are of the age of majority, I want you to sign a bond, okay, saying that I had given you money. Okay, in fact, the money is more than what A had spent to raise the son. So let's say if the father had spent about 300,000 ringgit, okay, the father now A, okay, asked the son to sign an agreement with him saying that B, okay, owes him, the son owes him money of 1 million ringgit. So this agreement between A and B is a voidable contract. Okay, because A is said to have induced undue influence toward the son. So that is actually an example that can be used to show that a father has a real and apparent authority over the son. Right? Secondly, okay, the example that I used just now was father, husband and wife. Okay, this can be seen in the case of Salwat Hanim and Haji Abdullah. I'm sharing with you in the live chat, okay, the name of the case. Okay, if you want to know more about the name of the case, you can refer to whatever references that you have, or even if you search, okay, on any of the search engine, you will come across, okay, the fact in this case. So, but basically, okay, just telling you briefly about the fact of the case. In this case, the plaintiff's husband, okay, had entered into an agreement to transfer a property, okay, belonging to plaintiff and the husband. Okay, so husband and wife own a property. Okay, husband then asked the wife to sign an agreement to transfer the property, at least the wife's share, to the husband's brother. So because of the husband told the wife, okay, you should sign this, the wife signed it. Okay, so the plaintiff agreed to the sale or the transfer of the land, but after the husband died, she brought an action against the husband brother or her brother-in-law, seeking to set aside the agreement. So she wants the agreement to be revoked. Okay, the court held that, all right, since there is a relationship between her and the husband used that relationship because the husband has a real and apparent authority over the wife, the court says that the agreement that she signed, okay, was induced by undue influence, the influence of her husband. So there you are. Okay, so that is the first situation when a person is deemed to have been in a position to dominate the will of another because he is in a real or apparent authority over the other. Okay, right? Are you okay? I can continue with the second presumption created by section 16, subsection 2. All right. Okay, let us move on. Now, the second situation where a person is said to be in the position of dominating the will of another is, okay, if he stand in a fiduciary relationship to another. Okay, again, if he stand in a fiduciary relationship with another. Okay, what is the meaning of fiduciary? Fiduciary simply means the position of confidence with each other. There is a confidential, okay, relationship between each other. All right, just like husband and wife, as reflected in the case of Salwat Hanim. Okay, the husband and wife, they are said to be in a fiduciary relationship because between them there is a confidential relationship. So if one of them uses that confidential relationship, okay, against the other, to the extent that the other party, the other person, okay, to whom he has a fiduciary relationship, agree to sign an agreement or to make an agreement with anyone else because of the influence of the first person, then it is said that he is in a position of dominating the will of another. So that's husband and wife. In one landmark case, okay, this is a quite interesting case. Okay, the court held that a solicitor is in the position, sorry, a solicitor is in a fiduciary relationship with his client. You see, when the client go to see a solicitor, okay, and engage that solicitor is lawyer lah, okay, another word to describe lawyer, okay. So when a client go to see a lawyer and instruct the lawyer to do some job for him, they are in the position of fiduciary relationship or confidential information, because whatever a client tell the lawyer cannot tell anyone else. So when you have that relationship, there cannot be disclosure of anything which is communicate to that person. And in this situation, the lawyer, we say that that is a fiduciary relationship or confidential relationship. So in the case of Datuk Jaginda Singh and Tara Rajaratnam, okay, solicitor, okay, told his client to transfer, okay, the client's land, okay, to someone, to him, okay, to him, to secure certain debts of the husband, right? So because of that, the client, which is actually a lady in this case, transferred the land, okay, to the lawyer. Okay, then subsequently she will apply for that agreement to be revoked. Okay, the court in this case held that the solicitor, being a lawyer for the client, okay, was in the position of dominating the will of his client, because there exists a relationship, what we call a fiduciary relationship or confidential relationship with the client. Okay, so there you are. Okay, that is in section 2, paragraph subsection 2, section 16, subsection 2, paragraph B. All right. Now, the third situation is where a person, okay, this is also in paragraph B, where a person makes an agreement or contract with anyone whose mental capacity is affected by reason of age, by reason of illness, by reason of mentally or bodily distress. Apabila seseorang itu membuat perjanjian dengan seorang yang kemampuan mental dia terjejas disebabkan umur, disebabkan sakit, ataupun disebabkan keletihan mental dan keletihan badan. So biasanya orang dalam keadaan ini, okay, dia mengalami masalah in the sense that dia tidak boleh berfikir dengan waras. So if you enter into an agreement with this kind of people, you are said to be in the position of dominating the will of the other. Okay, there are two cases. Okay, mungkin kat sini boleh menjadi contoh yang baik. Right, the case is first the case of Chait Singh, okay, and Budin bin Abdullah. In this case, the court held that, okay, a contract made with an illiterate person, okay, where the creditor charged 30% interest per annum, was a contract made by a person with another person whose mental capacity has been affected, okay, by reason of age, illness, mentally or bodily distress. Okay, so you buat perjanjian dengan seorang yang buta huruf, okay, perjanjian yang dibuat itu dikatakan telah disebabkan oleh undue influence. Okay, because at that point of time, as you know, that person is an illiterate person. The same in the case of Lakshmi, Arumugam, and Annamile. Okay, in this case also, a developer, okay, signed an agreement with an illiterate woman after making a false statement. The court held that, okay, the agreement had been induced by undue influence. So there you are. Okay, the second situation that can vitiate free consent. Okay, where a person, okay, had been unduly influenced. All right, and when is a person is said to have been induced with undue influence, where okay he enters into an agreement, okay, where one person can dominate the will of another and use that position to get an unfair advantage. Okay, and subsection 2, okay, gave three situations, okay, when a person is said to be in a position of dominating the will of another. One, when he has a real and apparent authority over the other. Okay. Secondly, where he is in a fiduciary relationship with another. And three, when he enters into an agreement with a person whose mental capacity is affected. So because of that, okay, he is said to be in the position of dominating the will of another. All right. Okay. The time now is almost 12:30. All right. So how's it so far? Can you follow me? Or have you been following me? Or have I been talking to myself for 1 hour? I suppose that's what people do in live session, isn't it? You talk to yourself, all right? I'm not the kind of person that actually talk to myself very often, especially in front of a camera. I need to go into a paradigm shift, lah, okay, to get used to that. Okay, thank you. Right, thank you for your support. Thank you for the hearts that you are icon that you are sharing with me. Today I'm not selling anything. Okay, I'm just selling knowledge. Right? Okay, let us now look at the third situation that can vitiate free consent. All right, notice you can give me flower. Fine, thank you very much. So the third is fraud, or in bahasa Malaysia, penipuan. Okay, I'm not going to detail on this. Okay, what is fraud? Fraud is defined by Section 17 of the Contract Act. According to Section 17 of the Contract Act, fraud is an act, okay, committed by a party to an agreement to induce another to enter into a contract. And what is fraud? Okay, the Act gave 5, okay, example of frauds. One, when you make a false statement and you yourself do not believe the statement is true. Okay, so making a false statement by one person who does not believe the statement to be true, that is fraud. Or in short, we call that fraudulent fraud. Okay, oh no, not fraudulent fraud, fraudulent misrepresentation. You make a representation. For example, I want to sell my car to you. The car is made a model 2010, but I went and tell you that the car is 2026 model. Certainly, I know very well that the car is not a 2026 model. I'm making a false representation. Okay, I myself do not believe that the car was a 2026 model, but yet I made a statement saying that it was a 2026 model when it was a 2010 model. So I am making a false statement. So in short, I have committed fraud. Okay, so that you entered into an agreement. So the agreement that you entered, okay, was caused by fraud. And you have the option to repudiate it or to continue with it. Okay, so that is the first one. Everything is in Section 17. 2, okay, actively concealing a fact by a person having knowledge or belief of that fact. Okay, you actively conceal. For example, in my attempt just now to sell the car to you, I changed the year, okay, in the registration certificate of the car. Okay, from 2010, I changed it, okay, to 2026. Okay, so the fact that I changed it shows that I had actively concealed a fact. Okay, and I know that, okay, 2026 is not the correct year where the car was manufactured. Right? So itu yang kedua. Yang ketiga, promise made without intention to perform. Okay, for example, you propose to your boyfriend or you propose to your girlfriend. You yourself, okay, have the intention that I am not going to marry this lady. So when you make a promise without any intention to perform, you are committing fraud. Even if the other party agree to it, okay, the consent that she gave was because of fraud. Okay, right. Fourth, any act that fitted to deceive. Okay, so anything, okay, that fitted to deceive, sesuatu yang memperdayakan. Okay, it could be anything. Let's say scam. Okay, I want to sell a car to you, and I take a picture of the car. Okay, not the actual car, but let's say a model car, and it looks like the real one, but instead it was a model car. My intention was only for you to buy this thing. So, and I put actually a very hefty price for it. I said 100,000. You then pay me 100,000, but you get a toy car. Okay. And you say that I did not get a car, I got the toy car. Yes, so the picture that I actually put on the internet, okay, for you to view is actually, it was that car. All right. So I am trying to deceive you. Okay. Anything that fitted something to deceive, that is fraud. And lastly, paragraph E, any act that the law declares to be fraud. So the one depends on the written law. If the written law says that that particular act is fraud, then that is fraud, right? So those are the example of fraud. Okay, and lastly, misrepresentation. Okay, misrepresentation, okay, is defined by section 18. Misrepresentation refers to a false statement, okay, made by a presenter, okay, to induce another party to enter into a contract. And according to section 18, there are three types of misrepresentation. First, a false statement made by a person who knows and believes the statement was true. You believe that the statement was true, so you make that statement. In fact, it was a false statement. So if the other party enter into an agreement with you or with anyone based on that, okay, based on that statement, it is said that the contract was entered by misrepresentation. So when you make a false statement, knowing and believe that the statement was true, this is what we call innocent misrepresentation. Right? Secondly, in section 18 also making a false statement while in breach of a duty without intent by misleading another person. Okay. Let's say I am under an obligation, a duty, because I have a duty to you, probably contractually. The duty is contractually. I am your lawyer, okay? And you ask me, what is the law on certain point? Then I give you, okay, the law. All right? I do not have any intention to mislead you, but the law that I gave was the wrong law. Okay? So if you enter into an agreement based on the statement that I made, it was false, it was not the correct law, then the agreement that you made, okay, with anyone, okay, can be repudiated because it is your consent to it was based on misrepresentation. And this is what we call negligent misrepresentation. Negligent misrepresentation. Right? And the third, making a false statement, however innocent that statement might be, causing another person to make a mistake as to the subject matter of the agreement. This is what we call innocent misrepresentation. I made a statement. The statement that I made was innocent. I do not know that it was wrong. Okay, then because of that, you make a mistake by entering into an agreement. And the mistake that you make was something important to that agreement. So the agreement that you made had been induced by misrepresentation. You can repudiate it also. All right. So there you are. Okay. So let us now come to the the last one, the fifth mistake. Okay. All right. Generally, the general rule is that, as provided by Section 23, okay, mere fact that one party to a contract made a mistake as to the subject matter of the contract does not make the contract void. Kalau seorang sahaja yang berkontrak buat kesilapan mengikut Section 23, alright, kontrak itu tidaklah terbatal. Alright. So this is provided by Section 23. Let us read Section 23 together. Okay, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. Okay, all right. So what is the type of mistake, okay, can lead to a contract to be void? Okay, ini ada dalam Section 21. In Section 21, it provided that where both parties to an agreement are under a mistake as to a matter of fact essential to the agreement, then only the agreement is void. Remember, it is not voidable, it is void. But the mistake must be done by both of parties. We say that this is what this is mutual mistake of fact. Both parties made a mistake as to the subject matter of the agreement. Then only the agreement is void. All right. So that is actually a good case for this, okay, where both parties makes mistake. Okay, the case is the case of Raffles and Rachel House. I'm sharing with you, okay, the case and the citation. Okay, Raffles and Rachel House. In this case, two parties agreed for the sale and purchase of a cargo of cotton arriving in London on a ship called Peerless. Dua pihak buat perjanjian untuk menjual dan membeli satu kargo yang mempunyai kapas dalamnya yang akan sampai ke London di atas sebuah kapal bernama Peerless, which sailed from Bombay. The ship sailed from Bombay, Okay. But unknown to both of them, there were two ships by the same name, both leaving from Bombay, but at different time. There were two ships named Peerless. How it happened, I do not know, all right? But just accept the fact. Okay? Two ships by the name of Peerless, and both actually were leaving Bombay, but at different time. When they were negotiating, okay, for the sale and purchase of this cotton, they both made a mistake. In their mind, one thing about one ship, okay, the other was thinking about another ship. Right? Okay, because of that, when the ship arrived, okay, the buyer says there was no cotton on it. Okay. Then another ship arrived, okay, the seller says there was cotton on it. Okay, so there was dispute between the parties. So in this case, the court held that the agreement that they entered into for the sale and purchase of the cotton was under mutual mistake, because both of them made a mistake as regard to something which is important about the agreement, which is on which ship does this cargo, okay, uh, is put, okay? Was it on the one peerless that was actually that sailed earlier, or was it on the other ship? So both of them were thinking about different ships. So the court says that it was, okay, a mutual mistake, and the court says that, well, the contract is a void contract. Right, so there you are, okay, the elements of free consent. Okay, just remember, okay, free consent is one of the important element to make a valid contract. If a consent is not given freely, the contract can either be a void contract or voidable contract. And what is, okay, what are the situation when a consent is said not to have been given freely? One, consent is not given freely if it was obtained by way of coercion. Two, if consent is obtained by way of undue influence. Three, if consent was obtained by way of fraud. Four, if consent was obtained by way of misrepresentation. And lastly, if the consent was obtained by way of mistake, mutual mistake. All right. So the meaning of, okay, what is coercion, what is undue influence, what is fraud, what is misrepresentation, and what is mutual mistake, everything is in section 15, 16, 17, and 18, read together with section 21 of the Contract Act. So I do hope that you go and read this section and get a better understanding. Right? Okay. I think I've covered what I need to do, okay, in this live session. So, do you have any question to ask? If you can use the chat box or the live chat. Okay. If not, I do think that that is the end of our session today, and I will see you again. Okay. Now, before that, if you have any doubt, since I'm not your lecturer, so uh, you can always, okay, you can always ask your tutor, okay, ask your tutor, okay, on anything that you don't understand, okay. All right, okay. I think with that, okay, anything else that you want to add or anything that you want to know, okay, you can always. If not, then I'll see you again in our next All right, with that, thank you very much. I see you again.